Welcome to this presentation, our first in a series talking about the topic Understanding the Law and Recurring Legal Concepts. We're going to get through about half, maybe even a little bit more than half of the material on this PowerPoint. I've got kind of a deadline because the family will be waiting for us to get in the car and go to church pretty soon, so I'm going to try to be as efficient as I can. Sometimes I know I ramble a bit. Y'all are too kind to say so, but I know my quirks. So anyway, I'm going to be try to be time on task so we can get as much done in as little time as possible. Let's go ahead and get started. We're going to focus on these first three items on our module outline. We're going to talk about kind of introductory stuff, a little bit of the history and the structures of employment law and just kind of law generally. And then we're going to talk about the topic of at-will employment. You may think, Gruber, we've already done that, and you're right. So we're not going to do a lot about this topic, but then we're going to do a tremendous amount on the exceptions to at-will employment. This is going to be like 80% of what we're talking about today. And so you may think when I say, well, we're just spending a little bit of time talking about at-will employment, but we're spending so much time talking about the exceptions, you might think, well, does that mean that at-will employment is just riddled with holes in it and there's almost no actual content? And not at all. These exceptions are important things to talk about, but at-will employment is a very vigorous, real thing, and we ought to recognize that at all times, that at-will employment really and truly is the rule, and these exceptions happen. Certainly, there are things that HR professionals and attorneys and paralegals who practice this area ought to be very aware of, but that doesn't mean that the exceptions are more numerous than the rule, by no means. So let's get started. You'll see many of these concepts we've already talked about, so I'm going to do a really brief look at some of these, and some of these slides I'm not even going to talk about at all. Let's talk a little bit about the difference between substantive law and procedural law. This is an important distinction. This course is all about substantive law. We're going to say almost, well, not almost nothing, but very little about procedural law. Let me give you an example about the differences. A substantive, or looking at law from a substantive perspective, would say what rights and obligations I might have under law. For example, a substantive aspect of Title VII would be that employees should be free from discrimination based upon their race or their religion or their gender. Procedural aspects of Title VII would be how long do I as the employee have to file my claim? When I file my claim, what's going to happen next? What is the EOC going to do? What is this right to sue letter that the EOC will issue, and how long after I get the letter do I have to file my lawsuit? So it's about how we enforce our legal rights. You might say substantive law is the what, and procedural law is the how of this areas of law. So the vast majority of what we say is going to be about substantive law, just a little bit about procedural law going forward. We've already talked about stare decisis, but let me just kind of refresh a little bit on this. This is just fundamental to our legal system, and not just ours, but all the common law jurisdictions out there. For the most part, if a country speaks English, it's a common law jurisdiction. So we see common law in Canada, we see it in India, we see it in Great Britain, we see it in Ireland, we see it in South Africa, we see it in other parts of the world in which English is a big factor. Usually that means that at some point Great Britain controlled that country and Great Britain had the common law. Other countries, such as countries in Latin America, most countries in Africa and Asia, and continental Europe don't have a civil law system, a common law system. They have a civil code system. That civil code is different than civil law. Everybody's got civil law, everybody's got criminal law. So that distinction exists whether you're a common law jurisdiction or a civil code jurisdiction. But the differences are important because in a civil code jurisdiction, what judges do doesn't have a tremendous amount of significance. It becomes a less important area of inquiry. We focus upon the statutes more. And in a common law jurisdiction, statutes are important, but usually statutes aren't as common a way of developing the law as we find with judge opinions. And so in a civil code jurisdiction, typically you find a very robust, systematic statutory schema, and the judge's opinions, that judge just really decides the case for those particular litigants, and the judge's decision doesn't have really significance beyond those two litigants. And of course, in our common law system with the doctrine of stare decisis, a decision issued by a higher court is not going to just affect the litigants, but is going to affect everybody for, up until the time that the legislature acts and changes the law. And so it's a big, big deal. So the role of the judges in a common law system is much more elevated than in a civil code system. Now, which is better? Neither's better. They're both awesome systems. They both have their strengths and their weaknesses. But whichever one is better is kind of beside the point, because the system that we have in the United States isn't going to be changing. We are going to be a common law system, and so it's best that we kind of address that issue and be aware of it. So here's a good description of what stare decisis, or the precedent system, is. Once an appellate judge, in other words, a higher court judge, renders a decision in a case, the decision is generally written and placed in a law reporter and must be followed in that jurisdiction when other similar cases arise. When the facts are similar, that controls. So that's what stare decisis is about. Here is a hierarchy of how we look at different primary sources of law. Examples of primary sources of law, we talked about these in previous lectures, so I'm not going to spend a lot of time on it. There are things like constitutions, statutes, regulations, executive orders, treaties, and case law. So you may think, well, if you have some of these tools that conflict with each other, you have a case that says X and a statute that says Y and a constitution that says Q, which one controls? Well, of course, they may say different things, but if they don't contradict, then they all apply. But when there is some level of contradiction, you need to understand the hierarchy to know which one controls. And this is the hierarchy we have in our country, and this is very common. In fact, I would say all common law jurisdictions have this. The Constitution of that country or that state is the most important document. It controls. So if a statute is passed that contradicts the Constitution, be it state or federal, then that statute isn't going to be in effect. The Constitution is going to trump it, so to speak. If a statute says one thing and a judge decision says something else and they can't be reconciled, the statute controls over the judicial opinion. This comes up fairly common in the law. You'll have a court render a decision, and then the legislature, be it the federal or state legislature, comes back and says, no, we don't like that. Classic example of that phenomenon is the Lilly Ledbetter case, where the Congress said, no, U.S. Supreme Court, you got it wrong. That's not what we meant when we wrote that statute. And as soon as that statute is passed, all of the cases that had a different interpretation, it's like they never even happened. They don't control anymore. So even though I said that the judges are really important and have higher status in our system than in the civil code system, it doesn't mean that they're more important than the legislature. The legislature is going to control unless, of course, there's a constitutional issue. Okay, let's think about a couple of things about the Constitution. Since we said the Constitution controls, where do we find that? Well, we actually find that in the Constitution, the Supremacy Clause. The Supremacy Clause says the Constitution is the supreme law of the land, and also that federal law it trumps state law. So that's another level that I don't have over here, but I could have included another level that said federal law trumps state law. So if we have a federal statute and a state statute that conflict, the federal statute controls. If we have a federal court and a state court talking about a federal law issue, then that federal court trumps the state court. If we have a provision in a federal constitution that breaches a state or that conflicts with a state constitution, then the federal constitution controls. So it's helpful to keep that ordering in mind, and we find that in the Supremacy Clause of the Constitution. A little bit of refresher on civics from high school, the idea of checks and balances. The Supremacy Clause is all about something called federalism. You probably remember that term. Checks and balances oftentimes gets confused with federalism, but it's really a different thing. You will have checks and balances in a jurisdiction that doesn't have federalism. checks and balances are the three branches of government as we understand it. Of course, we have the legislative branch where the Congress or the state legislature is. We have the executive branch where the president or the governor is. And then we have the judicial branch where the judges are. Each one in our system has its own responsibilities and its own limitations. And so every time the legislature acts, there's a check on it, something that the executive can do to limit the power of the legislature. Similarly, when the executive acts, the legislature is a check on the power of the executive. And the judiciary is a check on both the legislative branch and the executive branch. So that's where we have this idea of checks and balances. This is in place to stop us from having a dictator who could control the whole system and become kind of a czar or czarina of the system. So we're not going to go into the specifics of the checks and balances, but just be aware that those exist. And we can even see those checks and balances back here when we're talking about the hierarchy of these various levels of review. We've already talked about stare decisis, but here's maybe a definite. I have a couple of competing definitions because in my experience sometimes students latch on to a particular understanding, and so sometimes it's helpful to say it in a few different ways. So here's another way of looking at stare decisis, or the power of precedent if you prefer that term. Lower courts must apply prior decisions of higher courts within their jurisdiction in similar cases as binding precedent once certain common facts between the cases are established. Honestly, this is my preferred definition. I think this one is a really neat one. I think it captures the gist of stare decisis. We've already kind of covered this about the relationship between federal laws and state laws. Generally, federal laws control as a general rule because the supremacy clause, we call that preemption if there's a conflict. The first thing, though, to keep in mind is when there isn't a conflict, the federal laws and the state laws can coexist and do coexist. Now, when there is a conflict, how do we resolve that in employment law? Well, there's kind of two ways that you can imagine a system doing it, and actually in employment law we see both systems, but one is much more common than the other. So let's say that a federal law gives, let's see if the marker's going to work today, gives this level of protection. Nope, sure isn't. Let me see if I can. Nope, just not going to work for me. Okay, so let's say that a federal law gives this level of protection up to the word state to employees. Maybe it protects them against race discrimination and sex discrimination and age discrimination. A state law in that jurisdiction protects those same workers from marital status discrimination, maybe from sexual orientation discrimination. So it gives additional protections. In most situations in that state, both the federal protections and the state protections will occur. The employee will get the best of both worlds, both levels of protection. But let's say we had a federal law that protects citizens in that state against age discrimination for individuals 40 and over. And there was a state law that says, well, no, we're just going to protect people who are 50 years old and older. So people between their 40th and 50th birthdays aren't protected under state law. Well, in that situation, the federal law provides the most protection to workers, and so that's what's going to control. So usually the answer is employees get the best of both worlds. Whichever benefit is higher is what is going to control. But that's not true in every single example. The one that occurs to me that is different is going to be ERISA, and we'll talk about that later. Under ERISA, we have true federal preemption. Let me first of all explain what ERISA is. ERISA is it's E-R-I-S-A. Wish I could make that show up here, but in any event, it's the federal law that allows employers to get certain tax benefits if the employer provides certain employment benefits to its employees. And so it's really a tax statute, but from a practical standpoint, from an employee standpoint, it seems like it's a benefit statute and that it permits employers or motivates employers to provide benefits to employees. And so sometimes what comes up is that the federal statute puts certain limits on what employers can do if the employer wants the benefits. And there's certain paperwork that the employer has to follow. You need summary plan descriptions. You have to file certain things with the government when you want to offer certain benefits and get these tax advantages. Well, sometimes what happens is that a state will come around and say, we want to mandate that employers do this type of benefit. And so ERISA isn't far enough. ERISA says employers can give this benefit, but doesn't say an employer has to give this benefit. And so under the old schema that we were talking about before, when we were saying that the employee gets the best of whatever the benefit is, you would kind of expect that under ERISA that the law would say, okay, if a state wants to be more generous to its employees, that state law is going to control instead of ERISA. But that's not how it works out. If it's an ERISA plan, it doesn't have to comply with the more onerous requirements of state law. You may say, well, why do we have a different answer for ERISA compared to what we have for, say, employment discrimination? I'm not sure exactly all the ins and outs of how the Congress negotiated the law, but my guess is that there was a give and take. I mean, it's a political process. Maybe the conservative congressmen and women agreed to this particular aspect in exchange for that particular aspect from the liberal congressmen and women. And so where the parties end up on a particular day is a little bit of a somewhat unpredictable thing. And so we just have a different answer with ERISA. At this point, you're not required to know anything about ERISA. I'm just offering it as an example. The general rule in employment discrimination I have highlighted here. The rules in combination, both federal and state laws, will provide the employee with the maximum benefit under the law. Again, that ERISA exception and the other exceptions we'll talk about when we get to that material, we'll do a deeper dive into it. Here are some key terms. Many of you will have already heard of these terms, and so I'm not going to do a big deal of them, but you are responsible for knowing what a plaintiff is. That's the person who's suing. The defendant, that's the person who's being sued. In employment discrimination, obviously, the plaintiff is usually the employee, and the defendant is usually the employer. The appellant, see we have A-N-T at the end here, is the person who loses at trial and is appealing or going to a higher court. That obviously can be the plaintiff or the defendant, because obviously either one could lose at trial court. The appellee is the person who won at trial and who is trying to maintain what happened at the trial court level. Sometimes people call the appellant, I'm exaggerating the ant, people don't say it that way, but people talk about this person as being the plaintiff of the appeal and the appellee being the defendant of the appeal, because the appellant is trying to change something just like the plaintiff is trying to change something. We have a few other terminology I want to share. Case citation. This is where you find a particular case. We'll be looking at an example of this later on. The format for it is that we need to have the volume of the book. Maybe it's the 342nd volume in a series. The name of the reporter. Usually we have Southwestern reporters, what we use for state law cases, and we have the federal reporter for federal cases, and then the page where the opinion begins. Also relevant is the decision date. These books are published chronologically, so if you're looking at a particular volume, most likely you know within a year or so, or even less than a year, what the year of those opinions are. So this is important. This helps us find that particular case. It's a citation system just like you might use MLA or something along those lines. The term that we use for this in the law is called blue booking or green booking. Green booking in Texas. A motion to dismiss, first of all, I'll talk about the word motion. A motion is something that one of the litigants is essentially making a request to the court, please do something. And we sometimes say that a party moves to have a request made. And so this is a request, and you can see what the word dismiss means, to make it go away, right? And so a motion to dismiss is a request to dismiss a lawsuit. Well, as you can imagine, the plaintiff usually doesn't make that request because obviously you can't win if your lawsuit's dismissed. So usually it's a motion filed by the defendant. And it's usually because of some problem with the complaint. There's something missing, or there's something in it that means that the plaintiff can't win. If the court grants this motion to dismiss, then the lawsuit ends. Now, sometimes motions to dismiss can be without prejudice, which means that the plaintiff can refile if he or she wants to. Sometimes it's motion to dismiss with prejudice, which means plaintiff is out of luck. He or she cannot refile. Now, he or she can appeal the decision. So, again, in that situation, he or she would be the appellant who would be appealing that granting of the motion to dismiss. This is an important motion, but this is really the rock star motion. Motion for summary judgment, which is oftentimes called in the legal biz MSJ. This is the most important motion that you'll see in most litigations, especially important in federal court. And in the area of employment law, federal court is kind of the main place, which is a little bit unusual because most litigation happens in state court, but not in the area of employment discrimination. And that's especially true in Texas. Federal law is the more important system of law that we have when we're talking about employment law. So a motion for summary judgment is in many senses like a motion for dismiss. It just happens later on in the case. It's a motion, so it's a request, and we're requesting that the court render a judgment or a final decision in the case, but before trial. The word summary here means before you've had the full blown out trial. So this is almost like a briefer process, you could say. And so if it's granted, then the lawsuit ends, and that would be with prejudice, not without prejudice. And of course, the loser, and almost always the court rules in favor of the defendant when you have these motions, because the plaintiff bears the burden of proof. It's very difficult for the plaintiff to win by filing a motion for summary judgment, because the court will say, well, I mean, you have to meet your burden of proof. The defendant's entitled to a jury trial to resolve that issue. It's much more easy for the defendant to do that because, again, the plaintiff bears the burden of proof, and so it's much more likely that the defendant would file a motion for summary judgment, and much more likely the court would grant it. And of course, if the court grants this motion, then very likely the plaintiff will become the appellant and file an appeal. Per curiam, this is a term meaning when a decision by an appellate court is issued as a group rather than identifying the particular judge who wrote the opinion. So it's basically kind of an anonymous opinion. Sometimes it's done in cases in which the finding was just kind of a rote deal, very short opinion without going into a lot of details about the case. It's almost a kind of a jotted off quickly type decision. Occasionally, though, a per curiam opinion will issue over a more weighty subject. Okay, so we're done with that first section. Now we're going to talk a little bit about the history of labor and employment law. I'm not a big person to emphasize history, and what we care about, honestly, is what's happening today. So I'm just going to do a little bit of a brief system of this. First thing to keep in mind is just like our whole common law system came from England, guess what? Our employment law system, even though our employment law system is largely statutory, the notions that we have are things that we developed, our ancestors developed when they were in England. And so it has to do with the common law system, and also with the fact that there was an agrarian culture. I mean, I guess there was an agrarian culture probably everywhere. So typically employers were small. Most people were farmers, and so they weren't, maybe were even self-employed under those circumstances. Here's a list of important laws. I'm not going to go through these, but you can see that actually prior to 1900, there were almost no statutes in this area. And we see even up to the 1960s, 1963, other than labor laws, there was very little activity here. We have the minimum wage law, and we have some labor laws, but very little regulation of employment until 1963. And then, boy, does it come down the pike. Lots of changes in these areas of law, and there will be additional changes, no doubt. There's definitely an increase in these areas going forward. You're not responsible, by the way, for knowing any of these dates. We'll talk about many of these laws, but don't feel like you need to commit this picture to memory or anything like that. Okay, so employment laws we've already kind of discussed is a combination of federal law, state law, and even local laws. There are laws, for example, in the cities of Austin and Fort Worth that if you happen to be representing or involved in assisting employers or assisting employees in those jurisdictions, you need to be aware that there are some additional protections. For example, sometimes even in cities like Dallas, we'll see for city employees there may be certain protections that don't exist for the general population. So it does require a lot of awareness of where you are and where the litigation, where the issue has arisen, to see exactly what protections are in place. And of course, employment law is constantly changing. Employment law really is one of the places, almost more than any other area of the law, where we see the values in the culture are being reflected in the employment context. And certainly we are a culture that has seen dramatic changes in social values and also technology. And both of those naturally cause the employment law to change. Sometimes for the better, maybe sometimes not, but that's a value judgment. We're just here to kind of report the news and not comment upon it. And so we can expect to see lots of changes. If you leave this practice area for a year or two and you come back, you'll need to catch up, because there will definitely have been changes, and changes in the statutory area, but also changes in the common law and the judicial opinions that are relevant. Here's again a list of the sources of employment law. We've already talked about those, so I'm going to move on. Now we're ready for our second item. So we've kind of gone through our first item. Now we're ready for our second item, which is our discussion about at-will employment. Sometimes people call it at-will employment. Some people call it employment at will. Either way is perfectly fine. Okay, so when you start talking about employment law in the U.S., you have to start with employment at will. It is the concept. It is the organizing principle. If you don't get anything else from this course, you need to know that. And what's so interesting in our culture is, even though this is how it's all organized, such a large portion of workers don't know this, don't understand how important this is, don't get this idea. Employers, for the most part, do, but employees don't. They have this idea that they have to be given a fair shot. They have to be treated a certain way. I think they get that idea because good employers, smart employers, do treat their employees better than they are legally required to do. And so that causes employees to think, well, gosh, I've worked at 3 employers, and every place they've given me opportunities to improve my skills when I didn't know something. They didn't fire me the first time I messed up. That must be a legal requirement. When in fact, it's not at all a legal requirement. You can be fired because you're not doing a good job, but you can also be fired because you wore a green shirt to work and the boss likes blue and he never told you he likes blue, but he can fire you for that reason. It can be capricious, it can be unfair, it can be stupid, but that doesn't make it unlawful. Sometimes people think, well, but they can't fire me, or they're saying about 2 weeks notice. I'm entitled to something called 2 weeks notice. Not at all. An employer isn't required to give you 2 weeks notice, and you, the employee, are not required to give your employer 2 weeks notice. Now, employers like it, obviously, for you to give them 2 weeks notice when you leave, but you're not breaking any laws if you don't. Having said that, I highly recommend that you give at least 2 weeks notice, and as you climb the corporate ladder, it's a good practice to give at least a month's notice, and even longer if that's possible. Obviously, that's not always possible. The reason you want to give 2 weeks notice is not because it's legally required, but because you want to not burn bridges. You want that boss that you have now to be willing to give you a good reference in the future. And so by giving that courtesy, that notice, as you transition to the next place, you are not negatively impacting that relationship and possibly resulting in you finding it difficult to get the next job after the job that you're just about to assume. So it is a courtesy and it is a smart business plan, but it is no means a legal requirement. So here's a definition of at-will employment. Let's just look at it for a second. An employment relationship where there is no contractual obligation to remain in the relationship. Either party may terminate the relationship at any time. Sorry, I have the word time missing here. Imagine the word time. For any reason, as long as the reason is not prohibited by law, such as for discriminatory reasons. So I'm missing the Y there too. I apologize for that. This is a good definition. This is the law in every single state in the United States. Now, Montana, the Montana legislature would disagree with me. They would say, well, we're not at-will employment because we do have this statute. And it is true that they do. But you know what? As a practical rule, even in the state of Montana, there's very little variance from this standard. This is pretty darn close to what the rule is in Montana. But even if we exclude Montana, we have 49 states that are employment at will. And certainly this is the rule in Texas. You'll see in some jurisdictions that there are more exceptions to the employment at will doctrine than others, but the employment at will doctrine is very much alive and well in Texas. And that's true for the vast majority of states. Okay, so let's unpack the employment at will doctrine. It's an equal doctrine. It's an even-handed doctrine. The employee can quit at any time for any reason or no reason at all. And honestly, there's no unlawful reason for an employee to quit. An employee can never be kind of forced to stay. For one thing, we have something in our Constitution called the 13th Amendment, which prohibits involuntary servitude. So we can't be forced to continue to work, for a private employer. But of course, unfortunately, this is the downside of that first right of the employee, is that the employer has the same rights. An employer can fire an employee at any time for any reason: incompetence, stupid reasons, no reason at all, except for reasons prohibited by law. This is the category that we're going to find all of our exceptions that we're going to talk about later on. But again, don't make that error of starting to think, well, the exceptions are so numerous that they somehow make this rule be trivial or unimportant. By no means. This is the big rule in Texas and really almost everywhere. Employment at will is a legal contract between the parties, but we don't, obviously it's not a written contract, and we don't usually think of it as a contract, although it is. It's a contract that renews every second. If let's say I'm clocked into work, let's say I'm the Target cashier, every second I continue doing my job, and every second my boss isn't telling me you're fired, that contract continues. But let's say I'm in the middle of my shift and I'm up to here with it. I am so sick of this place, and you know what? I close the cash register, I take off my badge, I shove it into my supervisor's hand and said, I quit. I'm out of here. At that split second, the contract stops renewing. It is over. And guess what? Employment at will ended, poof, like that. Or let's say that I'm happily doing the job and my boss walks up to me and says, I'm done with you. You're out of here. You're fired. At that second, the contract has stopped renewing. The at-will employment is ended. As we talked about before, virtually all private sector employment is at will. Working for a government agency is much more likely to not be at-will employment. Also, if you are in a union facility and you are in one of the unionized bargaining units, your employment is probably not at will. And there are a few other private sector situations, but the vast, vast majority of private sector employment is under this relationship. This is an interesting case. I'm not going to go into the particulars, but I do want to point out a few things. This is that same structure that we've talked about before. There's really 4 things we're looking for when we're looking at an opinion. We're looking for what is the issue, what are the people, or what is the court trying to decide in this case? And then we're going to look at the facts. What actually happened to the plaintiff and the defendant that led to this lawsuit? We'll look at the procedural history. which this one actually doesn't include the procedural history, and then we'll look at the holding. This is obviously the most important part. For this particular case, you don't need to know the name of this case. This has to do with whether there was at-will employment or not. I've included this in here simply because it has to do with Mike Tyson, and so it's a little bit interesting to know a little bit about the boxing world and how Mike Tyson's career developed, and a little bit of that background. But again, you're not responsible for the case, just kind of an FYI. So now we've gone through the kind of the history and structure of employment law, and we've talked about what at-will employment is. Hopefully those are both pretty clear. And now we're ready for our last topic, exceptions to at-will employment. This is where we're going to be spending an insane amount of time, certainly the rest of this lecture. So keep in mind that whatever else I say for the rest of this lecture is about exceptions to this general rule. Okay, I'll try to remind as we go forward, because sometimes when we dive into the trees, it's easy to miss the forest. But it's important as an organizing concept to keep in mind everything else in this lecture is about exceptions to this general rule. Let's begin. And here's our list of categories. We're going to be talking first about violations of employment law. Then we're going to talk about bad faith or malicious termination, which may violate public policy, such as whistleblowing situations. And we're going to talk about implied contractual terms, just a little bit. This doesn't really work in Texas. I'm not going to do much on this. Then we're going to talk about the implied covenant of good faith and fair dealing. Again, this doesn't really work in Texas either. And we're going to talk a little bit about promissory estoppel. Most of our activity is going to be in these first two bullets. So I'm going to remind you where we are a little bit as we go through these, but just keep this organizing principle in mind. Know where we are as we progress. I'm going to jump around a little bit on the PowerPoints. And so as you're looking at your notes, or if you're looking at the PowerPoints, you're going to kind of want to jump around with me a little bit. And my numbering of the slides is going to be a little bit different than it would be on the one that I posted. It might be off by 2 or 3 slides, so be aware of that. Let's go forward. So we're going to talk about this first category, the violation of employment law. Let's talk first about the idea of wrongful termination. I can't tell you how many times when I was dealing with employees when I was in private practice, I would have an employee say to me, I'm going to sue you for wrongful termination. It was a little bit of a joke in the employment law area because employees think that that's somehow a claim in and of itself. It's not. An employee, before he or she is going to be successful with a claim, has to point to some law that has been broken in order to have a wrongful termination claim. I think what they're getting at is the idea that they think that because they were mistreated or because it was not fair, that means some law was violated. Now, as an employment attorney, I tried to counsel my client not to do unfair, mean, stupid things. Sometimes they did, but most of the time they didn't. So the characterization that this employee had, maybe I disagreed with, but what I would point him or her to is, well, you need to point to a law. Which law do you think was violated? And so that's what we're getting at when we talk about wrongful termination. It's termination contrary to the terms of a written employment contract. Again, this is rarely going to be in existence in Texas. Or a violation of anti-discrimination laws. This is this is the way that most plaintiffs win in Texas if they do win on this claim, or a strong public policy. Again, wrongful termination is much narrower than most laypersons assume. We're going to go forward from here. I'm going to flip now to slide 62 because now we're going to talk about retaliation and how retaliation arises in this context. So we're going from slide 32 to slide 62, so you're going to want to advance in your materials along with me. You'll see something. You may want to pause me if it takes you a little bit longer to find where we are. The title for your section in your notes will probably be Retaliatory Discharge. So what is retaliatory discharge? This is a term that encompasses terminations in response to an employee exercising rights provided by law. So again, this would fit under that category of wrongful termination. So you'll need to point to typically a statute that provides that a person, if he does X, he can't be fired for doing X. So that's kind of the concept. What the most common way that we see this actually develop in the law is when somebody files a claim of discrimination and they're still employed, or they are saying, maybe they haven't actually filed the claim, but they're saying, hey, I'm the victim of race discrimination or gender discrimination or age discrimination. And then they get fired. In addition to claiming that they're the victims of that type of discrimination, it's very possible they'll also say, plus I was retaliated against when I made that particular complaint. One thing I want to talk about also, this is in some respects a little bit off focus when we're talking about retaliation, is it's something that many times people get confused about. When I did that hierarchy of constitutional law being the most important, the most controlling, then statutes, then common law, sometimes that causes a bit of confusion for folks because they start thinking, well, I know as a resident and a citizen of the United States, I have certain constitutional rights. And so you just told me those are the most important. So I probably have a lot of constitutional rights when I'm at work with my employer. I can't fault your logic. Your logic makes sense when you say that, but that's not actually how it plays out because the Constitution primarily deals with our rights and responsibility vis-a-vis the government. So if I'm employed by the government, yes, I have a lot of constitutional protections in that employment relationship. But if I'm employed by Target or JCPenney or Frito-Lay or whatever private company, that's not the government. And so therefore, the Constitution has very little, I would say virtually nothing to do with that employment relationship. So the protections that employees have under the Constitution are only going to apply if they're employed by the federal government, not when they have private employers. This is a bit of a surprise to some folks. For example, we don't have the right to freedom of speech within the employment context. I mean, we have the right to speak. Our employer can't arrest us, but the employer can certainly fire us. If let's say my employer supports candidate A, or thinks that candidate A would be good to become president or governor, whomever, and I support candidate B, I certainly have the constitutional right to support candidate B, but my employer, if it's a private employer, is perfectly free to say, nope, we don't really like that, and so go away. And my constitutional rights haven't been violated. Now, of course, if I were working for a branch of the government that happened, absolutely, my rights under the First Amendment would have been violated. Let's look at this example here for a little bit more granularity. So Mary works for a private employer. While off duty, she participates in a rally protesting some government action. Mary's boss finds out about this and he decides not to promote her. He doesn't agree with her particular political view. Guess what? Mary's out of luck. She has no recourse. Now, of course, if Mary were employed by some branch of the government, a very different answer would occur. Okay, so what do we need to do, or what does the employee need to do if he or she has a claim of retaliatory discharge? He or she has to show first that he or she was engaging in participating in some type of protected activity, making a claim of some type. So for example, if I were to complain about race discrimination, it might be race discrimination that I myself am experiencing. It might be something that I observed in the workforce that I myself am not affected by, but I'm still protesting that in some sense. That would be an example of a protected activity. So you have to look to a statute or case law that says what Groover's doing there is protected. That's the first hurdle. We'll call that number one. Then number two, after this comment here, is the employer has to do something bad to me as a result of that. There has to be some retaliation. It can be termination, it can be demotion, it can be the lack of promotion, but I have to be able to point to something. And then, of course, there has to be a causal link between the two. It could have been that I was never going to get that promotion because I wasn't qualified, and the fact that I participated in that protected action had no impact upon the decision not to promote me. Well, in that situation, there is no causal link. So you need these three things in order to be successful as a plaintiff on a retaliation claim. As I said before, it can be the employee who's the victim of discrimination who complains about discrimination who can file the retaliation claim, or it can be a coworker who observes that Sally is being discriminated against and complains about it, even though the person who's complaining isn't being discriminated against. If something bad happens to the complainer, he will have or she will have a retaliation claim, even though he or she may not have an underlying employment discrimination claim. Retaliation claims may be filed not only for the adverse action taken while the employee was employed, but also after the employee ended. Let's say that I am terminated from my employment because of my age. And I complain a lot on Facebook about it and say, or maybe I file a charge of discrimination, this is a better example, with the EOC saying I was discriminated against because of my age. Well, my employer is very mad about having to respond to that discrimination claim, and so it badmouths me in the industry. It gives me negative references for employment, and so I'm not able to find other employment. And so in those cases, I have been negatively impacted even though I'm not currently an employee. I would have a claim of retaliation under those circumstances. So here, we already talked about the three elements: participation in protected activity, adverse employment action, and then that causal link. Let's explore a few more scenarios just to see how this can play out. Okay, so Mary files an employment discrimination claim, and she can also file a retaliation claim if she's demoted after filing her claim. And she's going to have to prove that causal connection, but if she can, then she's got potentially a good claim of retaliation. I'll tell you right now that employees are often more successful with the retaliation claim than the underlying discrimination claim. I would say most employers are more concerned about the retaliation claim than the discrimination claim in most cases. So this is a very meaningful concern. And as we said before, just like employment discrimination is an exception to the employment at will doctrine, retaliation is an exception to the employment at will doctrine. Let's look at the next example. Bob testified in a discrimination lawsuit. Before he testified, he was told, don't get involved, but he testifies anyway. Bob isn't promoted. Again, if there's that causal link, then he's going to have a retaliation claim, even though he doesn't have an underlying discrimination claim himself. He was just testifying on behalf of someone else. Let's look at our third example. Bob's desk is next to Mary. Bob overhears Mary's boss say to Mary that women should be homemakers, in other words, not be working in the work world. Mary files a claim of sex discrimination. Bob is denied promotion simply for supporting Mary during the trial. Again, Bob can prove retaliation under these facts, even though he doesn't have an employment discrimination claim of his own. So here are the things that we need for the prima facie case claims. We've already kind of gone through this before. These were the things that we were seeing here on this little arrow. Plaintiff has to show that it was engaged or he was engaged in protected activity or opposed discrimination in some sense. And then here I'm going to lump these two together. The plaintiff was qualified for whatever the position is that he or she didn't get. Maybe it was his own position because he was fired. And that he had some kind of materially adverse action. Usually we're thinking about termination, but it could be a denial of a promotion, or it could be a demotion or a reduction in pay or a lack of increase in pay. So these two are kind of combined under this one right here. And then finally, there has to be that causal link. Now, when we talk about prima facie case, this is the burden that the plaintiff has to kind of start the lawsuit. We'll talk about prima facie case lots and lots of times in this case. It's kind of spelled weirdly and pronounced weirdly. It's definitely a term you are going to want to know. Now, the prima facie case will vary a little bit depending upon the claims, but this is a pretty common way of presenting it. In fact, if you remember this paradigm, plaintiff engages in some activity or is in a particular category, was qualified, had material action, and there's some causal link. This is what we'll see kind of time and time again. But you know what? Plaintiffs usually don't have any problem proving prima facie case. It's pretty easy for them to do. but that doesn't mean the game's over. And in some senses, that's just the first inning of the ball game. Now the defendant has the option, and certainly will take advantage of the option, of presenting a lawful non-retaliatory reason for it. So again, going back to our example, Bob doesn't receive the promotion. Well, maybe the person who's promoted, we'll say Larry, was much more qualified than Bob. Yes, Bob did engage in a protected activity, and yes, he was denied the position, but and it may appear initially there was some causal connection, but when Larry, who's super qualified, gets the job, the defendant's going to be able to show that there was a lawful non-retaliatory motive for the decision. If the defendant is able to put forth or rebut the prima facie case, the case isn't over then either, because now the plaintiff can rebut the defendant's rebuttal by showing that, hey, defendant says Larry's more qualified, but he's really not more qualified, that type of thing. So now we're going to go back and we're going to go to slide 40. So pause me if you need. It might be more like slide 38 if you're looking at the slides. It's in that neighborhood. Here we go. Okay, now we're going to look at another statute. So we're still in that first section of exceptions to employment at will when we're looking at employment statutes. And a WARN is an example in this area. WARN stands for the Worker Adjustment and Retraining Notification Act. We'll talk a lot more about this as the course progresses. This is just kind of a little bit of an introduction here, but you do need to know this statute. And this requires that employees with over 100 employees, so we're not talking about tiny employers here, they have to give 30 days notice in advance of a plant closing or a mass layoff to employees who are affected. The idea here is that when the employer knows he's going to do layoffs, it's a courtesy, it's a legally required courtesy, to let the employees know so that they can make financial arrangements, maybe look for another job, maybe start saving some money so that they don't go to work one day and they're told, we're done. They don't have any ability to immediately get other employment. There are some exceptions to this statute. They're kind of the expected exceptions. For example, when an employer puts out a WARN notice, it's a public notice, and so you can imagine how difficult it is once you've done a WARN notice. If it's a business that's failing, it's difficult for that business to continue to try to be an ongoing business issue. So many times companies will delay doing the WARN notice in the hopes that they don't have to close their doors. And obviously that's in the interest of the employees as well. The employees, want continued employment more than they want a WARN Act notice. And so that's an exception. Another is sometimes there will be a dramatic change in business. Let's say the employer has one big client. The client cancels on them. They didn't know that was going to happen, and so they didn't have 60 days to plan for it. Or let's say there's a natural calamity and a hurricane comes through or something along those lines. Again, it wasn't something that could have been planned for. Sometimes employers choose not to give the 60 days notice because they're concerned about some type of sabotage that might happen with their business. Maybe the employees might destroy the equipment or something along those lines. So employers alternatively can just give 60 days of severance. They can tell the employees when they come in, we're done. Business is over. As long as they pay the employees for the 60 days, then they have satisfied the requirements under the WARN Act. Let's look at a couple of scenarios here. So we have a business in Galveston that's destroyed by a hurricane, and a company officially closes the facility and says, we can't repair it, it's just lost. So they terminate all 500 workers. And obviously they didn't give 60 days notice, but that's okay because it's a natural calamity. There's no violation of WARN Act under those circumstances. Okay, so Bob is employed by a company. He's a sewing machine salesman, a repairman, and in one of the plants, 500 workers are being laid off. It's being shut down one day when he arrives at work. No notice is given. There's no natural disaster. None of the exceptions we talked about seem to apply. So under those circumstances, Bob should be entitled to the 60 days of pay. Maybe it was done that way because of this concern down here. Okay, so now we're done with this first category. We've talked about the first category of exceptions to employment at will. So now we're going to talk about this next category. Bad faith or malicious termination may violate a public policy or other law or legal right, including whistleblowing. So now we're going to flip back to slide 33. So we're going to go back about 10 slides. Okay, so let's talk about whistleblowers. What is a whistleblower? You probably have heard this term enough that it's pretty old hat. It's what you think it is. A whistleblower is an employee who reports employer wrongdoing to a governmental or law enforcement agency. Whistleblower protections definitely exist in the public sector, and they do, to a limited degree, exist in the private sector. Some of the retaliation things that we were talking about earlier are, in some sense, whistleblower actions, and so some of those ideas exist. But in the private sector, you really need to be able to point to a statute that provides whistleblower protections. They aren't probably as numerous as some people might think they are. So what do we need to do to prove, and again, this is that retaliatory discharge paradigm that we talked about before, the protected activity. Again, in this case, it would be that whistleblowing activity. So you'd have to be able to point to a statute that protects you when you engage in whistleblowing activity. You'd have to, again, point to that adverse employment action and show that causal link. That same prima facie case that we were talking about before. We have two big federal statutes in the areas of whistleblowing. There's a lot others, but these are the big ones, and you are responsible for knowing them. The first one is the False Claims Act. And so this is one where an employer is when the federal government is the customer of typically a private sector entity. And so under those circumstances, there's been some shenanigans, supposedly, with respect to the contract with the federal government. So this would apply in private employer situations, but the private employer has to be involved in federal contracts. So that's not going to be most employers. And then we have SOX, and SOX is quite a bit broader. It's going to apply to basically all publicly traded companies. So if it's a privately held company, if it's not, the stock is not generally available, say on one of the exchanges or whatever, SOX doesn't apply. But if this is something that is a publicly traded company, SOX does apply. SOX became law after the Enron and WorldCom scandals in the late 1990s and early 2000s. This was designed to tighten up the accounting procedures that were being used so that some of the fraud and other misconduct that happened would be less likely to happen. I was still in practice at that point, and boy, everybody was very, very scared about SOX, which stands for Sarbanes-Oxley Act, but typically it's called SOX. We just didn't know how it was going to be interpreted, and it was really open to lots of different interpretations. It has ended up being fairly toothless. There's not a lot of successful actions in the SOX area. That doesn't mean it's not something you ought to be aware of and take seriously. Certainly, it is in the interest of companies to be rigorous in their accounting and auditing procedures, both for the benefit of the stockholders and the employees, but it's perhaps less terrifying as we initially thought. There are other statutes too that we're not going to dive into. This is a case we're not going to spend time on this, Garcetti. This is, again, we see that same system that we talked about for the issue, the facts, the procedural history, and then the holding. This has to do with public employees, and certainly we're going to talk sometimes about public employees, but most likely you are going to be assisting companies or individuals who are working in the private sector, and so you do not need to know the name of this case. We're going to now flip to slide 67. It might be 65 in your notes, so you might want to pause me as I flip to 67. Okay, this is going to be actually right after where we were talking about retaliation before. Public policy exception. Again, this is our second category for exceptions to the at-will employment doctrine when we're talking about public policy. I think it's useful to pause and just talk about what is public policy. Public policy is, here we go, a definition, a legal concept intended to ensure that no individual lawfully do that which has a tendency to be injurious to the public or against the public good. So when we talk about public policy, obviously this is something that the legislatures and the courts are trying to be consistent with. When the legislature acts, obviously it's only going to act, or is only going to say it's going to be acting for the good of the public. But when we talk about public policy, many times what we're saying is the legislature hasn't acted in this particular area. Maybe it's a cutting edge thing, a technological thing, or perhaps it's a social thing that has come up. And so we're trying to grapple with something ahead of the legislature, so to speak. The courts have to make sense of this situation before the legislature can dot their I's and cross their T's. And so the courts are trying to figure out what is the public policy in this area. So usually when we talk about public policy, we don't have well-crafted statutes yet. Here we have, let's look at this particular blurb here. Violations of public policy usually arise when the employee is terminated for acts such as refusing to violate a criminal statute on behalf of the employer, exercising a statutory right, fulfilling a statutory duty, or reporting violations of statutes by an employer. So you can see this has whistleblower kind of written all over it. That's not the only public policies that exist in our society, but in the employment law context, this is a big, big category. So this is a good example of that. Of course, whistleblowing is tied up with this one too. We've already had a definition of that. We have, again, some federal protections if the person is a federal employee, but we also have some state protections. Unfortunately for employees, in Texas, the limitations for whistleblowers are pretty modest. So let's look at what they might be in Texas. There is only one common law exception. Again, when you see this, think Texas case law, think judicial action in the employment law area, and it's in Sabine Pilot. That's the name of the case. And this is the standard. An employer cannot fire an employee for the sole reason of the employee refusing to perform an illegal act. That's it. An employee reporting that an employer committed a illegal act isn't protected. If an employer fired an employee because he refused to perform an illegal act and some other reason, then it's not the sole reason, and therefore it's not protected. So this is an incredibly narrow exception to the employment at will doctrine. Now, we have statutes in Texas, for example, statutes relating to employment discrimination, that provide additional protection against whistleblowing retaliation, but the only common law, the only judicially made one, is this one. And this is a big deal in Texas. This case, if you practice in Texas in HR, in the areas of HR or the areas of employment law, you are going to know Sabine Pilot. I'm going to go ahead and pull up this case at this time. I'm going to show you how to do this. This is a useful skill to have. Otherwise, we talked about reporters earlier, about where you go about finding reporters. But if you don't have access to the whole case law of a particular jurisdiction, you don't need it, because guess what? Google is our friend. The Google has done the hard lifting for us already in this area. So you just type in scholar.google.com and you go to case law. And in this case, we're going to be looking for Texas state decisions. Obviously, if we're looking for federal court decisions, we click here. And I am going to type in the name of the case. Here it is. And it's going to take me right to it. This is the Texas Supreme Court case. It's back from 1985. We can see here's a statement about the issue of the case. The sole issue for our determination is whether an allegation by an employee that he was discharged for performing an illegal act states a cause of action. And again, as we see here, we'll see all of the facts of the case above. And here we have an announcement of the holding. We'll just read this whole paragraph. While careful consideration of the changes in American society and in the employer-employee relationship during the intervening years since this earlier case, we hold that the situation which led to that decision has changed in certain respects. So in other words, this court, this Texas Supreme Court, is modifying, in some sense overruling this previous precedent. And it can do that because it's the highest court in the state. We now hold that public policy as expressed in the laws of this state in the United States, which carry criminal penalties, requires a very narrow exception to the employment at will doctrine announced in this case. That narrow exception covers only the discharge of an employee for the sole reason that the employee refused to perform an illegal act. So it wouldn't apply if the employee were simply demoted or denied a promotion. It wouldn't apply if there was more than one reason the employee was being terminated. And it wouldn't apply if the employee was simply going to report an illegal action, but only if he refused to perform the illegal action. And of course, this word and should be and. This D is wrong. We further hold that in the trial of such a case, it is the plaintiff's burden to prove by a preponderance of evidence, this is the usual standard in civil cases, that his discharge was for no reason other than his refusal to perform an illegal act. It's a really narrow exception. And courts since then have chosen not to broaden it. You do need to know the name of this case and its holding. So now we're going to flip back to slide 43. We're going to talk about other exceptions to employment at will. We're still in that second category. So now we're going to talk about tort liability. So what is a tort? When I think of the word tort, sometimes I think about dessert, right? Bavarian tort or a Sacher tort or something like that. A tort is, this is the definition, is a violation of a duty other than one owed when the parties have a contract. This is a really deeply unsatisfying definition. You have a duty and you didn't do it. That doesn't tell me much. While this definition is deeply unsatisfying, there really isn't a better one. It's a little bit like defining the word red. If you go to the dictionary and look up the word red, there's going to be a definition. But honestly, if you don't know what the word red means in English, you're not going to be able to make sense of the definition. It's such a basic concept in our language that you just can't define it. You either know it or you don't. And so in the law, tort is one of those just fundamental definitions, one of those initial building blocks of our legal system that just doesn't lend itself much to a definition. So we're going to kind of have to live with this situation. Almost all tort law is case law. Again, it developed back in England hundreds of years ago. And while we have tailored it to our culture today, probably 90% of it is what we inherited from our forefathers. So it's been a pretty stable system and relatively little in the way of case law. We're going to look at just a few torts that are especially meaningful in the employment law context. One that I'm going to focus on is the tort of defamation. In order to have, when we talk about elements of defamation, we talked about this a little bit with Prima Facie case, that we had those 3 or 4 elements, depending on how we characterized it. When we talk about elements in the law, we're talking about the things that you have to prove if you're the plaintiff. If you want to win a claim X, then there's more granularity. There's pieces of X you have to prove. And so in this case, if you're the plaintiff and you want to prove defamation, you need to prove these 3 things. And again, this is the employment law context. So the plaintiff to win defamation would have to prove these 3 elements, all 3 of the elements. The employer made a false and defamatory statement about the employee. The statement was communicated to a third party. There should be a Y here. Sorry about that. Communicated to a third party without the employee's consent and the communication caused harm to the employee. We need to have all three of these things present in order for the plaintiff, the former employee, to win. So let's look about an example here. Mary resigns from her place of employment. Bob, the store manager, tells other employees, this is the third party, that Mary had been fired. So she said she resigned, but actually the boss is saying something different. Not just fired, but fired for coming to work drunk. It's false and it's harmful to Mary's reputation. He also communicates this to somebody who is calling to verify her previous employment. So this is another third party. This is causing Mary harm. This first part may not have caused her economic loss, but may have hurt her reputation. But this one, because it's going to affect whether she gets employed or not, that is actually causing her financial harm. And so it looks like Mary has a pretty good case for defamation under those circumstances. When an employee commits a tort, again going back to the example I had last time where I am the cashier at Target and I sucker punch Bob, the customer, and we decided that Target was going to be responsible under a vicarious liability theory, the particular theory being respondeat superior. Well, guess what? That punch I gave to Bob is a tort. And so employers become liable for the torts committed by their employees because of this doctrine, respondeat superior. I'm not going to go through this case. This is an interesting one about Texas A&M. You might find it interesting. It's also an interesting look to see how our culture has changed. As always, we see the various parts of this decision. Let me just for interest's sake, we're going to go find this case on Google Scholar. I think this would be interesting. But before we do this, just look at the pieces of it. We have an issue. We have the facts. We're going to have, actually I don't list the procedural history here, but we have the final holding. So the way that we're going to do this is we're going to look up Wagoner and Texas A&M. We're going to have to go to the federal court system because we are not in state court. So we're going to go back to Google Scholar. Here we go. So we're in scholar.google.com. We're going to go to federal courts this time, and I'm going to type in Wagoner, Texas. I'm going to type in university. I'm not sure exactly how they did. Here we go. Wagoner at Texas A&M University. So this would be the case. Just kind of showing you how to play around with these things. You should be able to find through this mechanism virtually every case I cite in my notes. So if you have trouble finding one and you want to read it for yourself, which I encourage, let me know and I'll be glad to help you find a case that might be a little bit more challenging. You aren't responsible for knowing this case. It's just kind of an interesting take on this area of the law, defamation, and other areas. We've already talked a little bit about defamation. Defamation is actually an umbrella concept that has two subcategories. One is libel. This is when the defamation is published somehow, maybe in emails, maybe in memos, maybe in letters. The other type is slander, which is a less serious type, and this is when it's just verbally stated. The way that legal professionals keep this straight is that the L in libel reminds us of lasting letter. It's a permanent record, and so the lasting letter starts with L's just like the L in libel. Slander starts with an S, and it's like spoken. By the way, libel doesn't have to be written. If I were to post a YouTube video with nothing written in it at all, that's a permanent recording, and so that would be a type of libel instead of a type of slander. Whenever we have whichever type of defamation we have, we always have to have some type of publication. Now that doesn't mean publication like a book or like a magazine or something. Publication in this context just means it has to be communicated to a third party. So let's say I'm talking to Bob and I say, Bob, you're a jerk, you're an awful person. But nobody other than Bob hears that. What I'm saying may be a complete lie, may be a complete defamation against Bob, but I can't defame him to himself. There has to be a third party involved. So if I'm talking to Bob and Susan and I say, Bob, you stole my car, now if that's a false statement, now I have published it to Susan, and so we have defamation. The area that defamations become so important in this in employment law really rises when an employer is asked to give a reference. Because you have a former employee, maybe you fired them, maybe you didn't, and you get called from some potential employer, hey, tell me about Bob. And so you have to make a decision at that point. Do I say something? Do I say nothing? Do I say something? If I say something, what do I say? Most employers wisely choose not to give any type of reference other than dates of employment, possibly wages and titles. That's safe to do because those are pretty much indisputable facts, right? And really there isn't a lot of benefit that the employer has from giving a reference. I mean, it helps that other business and it may help that former employee, but it doesn't really help your current employer. So wisely, most employers choose not to provide anything other than kind of the name, rank, and serial number type of references. But most states, including Texas, have come up with a statute that is designed to protect former employers who give job references. And here's our statute right here. And I've highlighted a little bit of the language of the statute. If an employer gives a false reference on an employment check, the former employee has a pretty uphill battle in Texas to successfully sue. That employee has to prove by clear and convincing evidence. This is a higher standard than preponderance of the evidence. Has to prove by clear and convincing evidence that the information disclosed was known by that employer to be false at the time of the disclosure, or that the disclosure was made with malice or reckless disregard. So the things to keep in mind are that clear and convincing evidence standard, and that there was a recklessness with respect to releasing the information. Even despite this language, though, most employers in Texas, they're wise, are not going to give substantive employment references. It's just not a good idea. Here's a case that is from the state of Vermont, so it's not directly relevant to us. I don't think that the outcome in this case would have happened in the state of Texas, so you're definitely not responsible for knowing this case. But I do want to draw your attention to this one item, which is called self-compelled defamation. This is an area of the law that we sometimes see some activity. In order to explain prior job history during an interview, a former employee has to say kind of what happened in the previous job. So let's say that I was falsely fired for theft. I'm in an interview and the potential new employer says, well, why did you leave your last place of employment? Well, I mean, I could lie, but if I'm going to be truthful, I have to say, well, I was fired because my boss thought I stole. I didn't steal, but that's what he thought. Well, it's very likely if I say that, the place that I'm applying is going to say, we don't want to take a risk. Maybe you didn't steal, maybe you did. It's just too much of a risk for us. And in that case, there really isn't, that former employer hasn't published the false statement about me to anybody, so there's no publication by the former employer, but in some sense, I have published it myself by having to tell subsequent potential employers. And so some jurisdictions have accepted this idea of this defamation, that this being the final piece of the defamation, the requirement that, who's here? That it was communicated to a third party. Actually, the victim is the one doing the communication. Don't know if that would be a successful claim in Texas or not. Here's another caveat to point out. We have employment at will, but if you hire key employees from a competitor, not because they're the right people for your operation, but for the purpose of crippling that competitor, you might be subject to tort action for the tort of interference with contractual relations. We'll talk more about this later on, but this is something that is kind of a touchy, somewhat difficult area to navigate a little bit from a legal standpoint. We'll also talk about invasion of privacy claims when we progress in this case, but I want to flag just a few. We usually think about there being 4 or 5 torts in the area of privacy in invasion of privacy. In Texas, we probably recognize 4 of the 5. And so I'm going to just flag these. This would be invasive surveillance or investigation of private affairs. We do recognize this tort. This would be if I wiretap somebody's phone, for example. Another is intrusion into seclusion. Me getting a high-power camera on my own property and zooming it in to see you as you are sunbathing or something along those lines. That's probably something we do. We'd call it a little bit something different. We call it unreasonable intrusion into a person's private affairs. Publishing information that puts the victim in a false light. Texas probably does recognize this tort. So saying something like a headline, Bob charged with crime. Well, his crime was that he jaywalked. It created the impression of something much more serious than was in fact the case, even though there was no actual lies. And then appropriation of another's name or likeness for economic benefit. We definitely recognize this. If I take a picture of Angelina Jolie and put it in my advertisement, even if I own the rights to that picture, I would be implying that Angelina Jolie has endorsed my product or uses my product. She makes her money by making those types of endorsements. For me to take that picture, I'm basically taking money from her, and so she would have the right to sue me under that basis. When a termination results from a wrongful invasion of privacy, of course, an employee can claim damages. An example would be if the employer wrongfully invades the employee's privacy, such as searching her purse without prior permission and maybe subsequently terminates her, that termination could be wrongful. Let's look at an example here. Mary works for a particular company. There's some things that have been stolen or missing, and so the company decides without any warning to start checking purses and bags. This is unannounced, and when they go through Mary's purse, they don't find any of the things that are stolen, but they do find some alcohol in her purse. They terminate her even though Mary hasn't come to work drunk or anything along those lines. It's possible that Mary can claim wrongful invasion of privacy. Again, we're looking for exceptions to the employment at will doctrine, and a tort claim would be an exception under those cases. So those would be possible avenues for action. False arrests. False arrest claims oftentimes come up when an employee is being investigated for a theft type situation and is being detained as that investigation goes forward. Employers should be cautious about accusing an employee of theft or commission of crimes because the employee might sue if it doesn't end up in a criminal conviction. That's why it's pretty common when employees who are terminated for theft, the reason that is given often sounds kind of weird, like violation of company policies and procedures. Why didn't you just say theft? Well, maybe it didn't meet the legal definition of theft, even though it was a violation. For example, let's say I take home boxes and boxes of office supplies. Well, maybe I'm going to say, hey, I thought I was allowed to use them at home. I was going to return them eventually, even though I've had them for 5 years at my home. Maybe that doesn't technically meet the definition of theft, but certainly it probably violates the policies and procedures of the company. Another situation that arises is false imprisonment claims, and this is when you're actually doing the investigation of the theft, and so you might restrain or limit that person's movement during that particular time. It needs to be for an appreciable amount of time, and you're kind of compelling them to stay against their will. You definitely don't want to physically restrain them, but even if you're restraining them through threats or intimidation, if you don't stick around, we're going to fire you for sure, that still can be a false imprisonment situation. Now we're going to slip to slide 69. Oops, here we go. So we've gone through our first two categories, the employment law category and the other legal basis category. And so let's go forward and talk about implied contract. What is an implied contract? It's a contract that is not expressed, but instead created by other words or conduct of the parties involved. It is probably not a very useful claim in Texas. So what we have here is the employer has made some type of promise The worker has relied reasonably. Again, this is that word that we'll see, which means that's an objective standard. How would other people in this particular circumstance, the average person in this particular circumstance, respond to that? Would they have reasonably relied upon it? And of course, the promise is somehow not fulfilled and the employee is disadvantaged. We call this doctrine promissory estoppel. And you can see we have the promise in the word promissory. Estoppel means that the the employer is stopped from breaking the promise because of this reasonable reliance. So you can see the word stop in the word estoppel. So promissory estoppel arises when the employer, or oftentimes this is a prospective employer situation, makes a promise that the employer reasonably relied upon to his detriment. And so this can be an exception to that employment at will if the employee can show he relied reasonably upon that promise. Okay, contracts usually have implied in them a covenant of good faith and fair dealing, and this can be an exception to the at-will employment. The implied covenant of good faith and fair dealing means that any agreement between the employer and the employer, because again, this is a contract, even if it's not written down, includes a promise that the parties will treat each other fairly and in good faith. This is an argument that is very successful in some jurisdictions, such as California. Not so effective probably in most places here. Let's look at an example or a little scenario here. So Bob's an employee. His monthly income was supplemented by substantial commissions that the company has promised to pay him based upon his performance. He's been working on a big deal for 5 months and has almost, I guess, finalized the deal. I don't know why I say the word seized here, but finalized the deal, and he's fired right before it's finalized. The deal actually does go through, but Bob is no longer employee, so he doesn't get that commission. Bob could argue that he's entitled to the commission because it looks like he was fired so that he wouldn't have to be paid the commission. That's actually an argument that could work in Texas. It would have to be pretty darn close to paying out, so you'd have to have facts that indicate that there's a very close connection between those events. This is a California case. This is definitely not the law in Texas, but this is an important case in California. And so if you happen to be practicing out there, you definitely need to know Foley. We'll see that same development or organization of our summary about the case. When you're looking at the cases, be sure to look for these factors: the issue, the facts of the case, the procedural history, and the holding. Again, you don't need to know this case because Foley wouldn't have been successful in Texas. So now we're down to our final category, which is termination because of promissory estoppel. We kind of already talked a little bit about this. Let's talk a little bit about constructive discharge. When does this arise? Well, this happens when the employee is given. That's a typo there. It shouldn't be his given. It should be is given. So remove that H there. Is given no reasonable alternative but to end the employment relationship. He isn't technically discharged. Nobody says to him, "You're fired." But the conditions are so awful, it's obvious the employer wants the employee to quit and is trying to force the employee to quit. Even though the employee actually does quit, it's considered an involuntary act on the employee. This is a pretty hard standard to make because employers aren't required to be nice. They're not required to treat their employees well. So it has to be pretty extreme facts. Constructive discharge usually evolves from circumstances where the employer knows that it would be unlawful to terminate under those circumstances. So the employer is saying, we can't fire this guy, but we want him gone. How can we do it? The standard is pretty difficult here. It can't just be unpleasant working conditions. It needs to be pretty extreme. And cases have gone both ways on these type of points. So let's look at the scenario here. Mary was working in as a marketing executive. They want to fire her because some people don't like women, but they know if they fire her because she's a woman, that's a violation of the law. So they say, what can we do? Well, we're going to put a lot of pressure on her. We're going to give her really, really onerous work. We're going to exclude her from meetings. It's really, really a miserable place. So Mary says, I can't handle this anymore. This is so awful that she quits. Well, under these extreme circumstances, Mary very possibly will have a claim for a constructive discharge. Now, of course, if Eagle Company had the legal right to discharge her anyway, let's say they discharged her wanted to discharge her not because she's a female, but because She went to college X instead of college Y, and everybody likes college Y better than college X. Well, because Eagle Company had the legal right to fire Mary because she went to the wrong college, you can't have a constructive discharge, successful constructive discharge claims under those facts. So if the underlying decision to terminate Mary would have been lawful, a constructive discharge claim isn't going to work. So now we are at the end. We've covered our first three categories. We've discussed the origins and structure of our legal system. We've talked about the doctrine of employment at will, and we talked about the exceptions to employment at will. Here's our list of exceptions. We talked about violation of employment law, including retaliation law, employment law such as employment discrimination. We also talked about the Warren Act, for example. We talked about bad faith or malicious termination in violation of public policy. We talked about the Sabine pilot case. We also talked about whistleblower statutes more generally. We talked about the breach of implied contractual terms. Things like handbook terms can put some limitations, but probably not in Texas. We talked about the breach of the implied covenant of good faith and fair dealing. Works in California and a few other states, but probably not in Texas. The big case in this area is the Foley case. And we talked a little bit about the doctrine of promissory estoppel. These are the exceptions, but never forget that the main rule, the employment at will rule, is the one that usually controls. I hope that this presentation has been helpful. Thank you for your attention, and I hope that you have a wonderful day. If you have questions, please feel free to email them. Thanks so much. Bye-bye.